Since we are back on the record, at this time, I'll entertain a motion for the board panel to return to regular session.
I'll make a motion.
It's been moved, properly seconded. All in favor, please signify by saying aye.
Aye.
Any opposed? The motion carries unanimously. The board panel is now back in regular session. Following deliberation on the motion to dismiss for license number 858-628 NP. Panel renders the following. The motion to dismiss is denied. Following deliberation on license number R 893-757, the board panel renders the following. The motion to dismiss is denied. Following deliberation on license number R 878-689, the board panel renders the following. The motion to dismiss is denied. Following deliberation on license number R 873-604, the motion to dismiss is denied. With each of the aforementioned motion, the panel makes the recommendation that the transcript request be made within 7 days of receipt of the final order. Following deliberation on license number P 327950, the board panel renders the following. The motion to withdraw by the state is accepted and approved. Are there any questions? You may be excused. Thank you.
All right, so now that we have finished up on the motions to dismiss, there is one last matter that we need to address, and that is the election of the nominating committee. And so at this time, I would like to take nominations for 3 persons.
Madam Chair, I would like to make a nomination for the nominating committee, please.
Okay,
Ms. Dan Collins, Ms. Lacey Gentry, and Dr. Michelle Owens.
any others?
Second that motion. And I would make a motion that we close the nominations and let 3 be elective acclamation.
I'll second that.
And that will conclude the rest of that. All right, Tuesday. Great. All right, so at that point, we're gonna ask for all those that approve, say aye.
Aye.
Any nays? Okay. Yes. So we're gonna move forward with that one.
At this time, the next matter before the panel will be license number R 866-201. This is a full board appeal.
So at this time, I would like to get a motion to adjourn the business meeting.
I'll make a motion.
Okay, so there's a motion and a second. At this point, we are adjourned.
Aye. Aye. I'll be careful. I'll call you later.
Oh, yes, sir.
Yeah, y'all are gonna have some.
I was just counting. up.
We need seven to have a forum. 1, 2, 3, 4.
We'll have 7.
We just need seven for this forum
Me and Laura that heard it.
after the three that recused. The three board panel members that were on the original were,
Laura, Mary, and Sandra, right? Yes, so they're.
no,
Jerry.
Jeremy.
And he's
Laura.
not here.
Miss Laura, yeah.
But that was just reading off.
All right, good.
Yeah. you did. Welcome back.
I looked at it earlier.
Back, Ms. Wiggins.
But Mr. Cummings, Miss Moore, and Dr. Stewart were the three that voted in this case. So those three would be the ones that would need to recuse themselves. Motion number 30. I heard you. Oh, sorry. I may be tired. In exhibit A, at least of the appellate brief, I think it's also in the appellate brief, shows those board members that voted on the original revocation. And that would be Jeremy Cummings, Laura Moore, Mary Stewart. So those are the board members that would need to recuse themselves. The full board hearing, or full board oral argument, excuse me.
Do we have any other board members who need to recuse themselves from this proceeding?
That's we'll still have 3 RNs and 2 LPNs, correct?
1, 2, Laura, 3, 1,
Yeah.
2. Yeah. I'm done.
Sure. It's always a,
Oh, yeah.
So what do we do?
Yeah, let's do it.
All right. Because that paper down there has members.
you couldn't hear it anyway. Regardless, so thank you.
All right.
All right.
What you say? I don't understand.
I don't understand it.
But I'm just reading the final order. And it says here, panel was comprised of Sandra Culpepper, Jeremy Cummings, and Mary Stewart. Laura Moore was serving as alternate. So if the final order is incorrect, then something is. That's,
Trying to figure out.
This is exhibit B in this.
So it's an exhibit B of 9. So I guess the final order is incorrect.
No objection.
I'm trying to determine if we would have 7,
We would.
even if all 4 are, none of these 4 are hearing, Ms. Culpepper, are you hearing the matter? Or you're still probably on anything you're.
Yeah, I mean, I have to for the record. I'm sorry. Yeah.
So we're ready to proceed.
Yes.
Ladies and gentlemen, we can dispense with this. If you just want to overturn the hearing panel and no issues, we can go on about our business.
Okay, this is an appeal before the full board regarding license number R 866-201. I ask that the board members would identify themselves for the record, please, starting on this end.
Nancy Norris Johnson, LPN.
Dr. Melissa King, nurse practitioner. Jane Clinton, Loria.
Alfred Shaw, nurse practitioner.
Sandra Culpepper, LPN.
Missy Gentry, RN. Holly Walker, LPN. J.M. Collins, consumer member.
Thank you very much. We will proceed as follows. Appeals of the decision of the board hearing panel shall be heard before at least a quorum of the full membership of the board, which would be 7 members. Appeals before the full membership of the board shall be limited to the record of the hearing before the board hearing panel. The full membership of the board shall not retry the appeal case. Argument shall be directed solely to issues from the record of the transcript that results in the appeal decision and shall not include new evidence, testimony, or witnesses. Respondent, appellant, and appellee shall each be allotted 20 minutes to present arguments why the decision of the board hearing panel should be overturned or affirmed unless otherwise ordered by the board. Respondent appellant may reserve a portion of his or her allotted time for rebuttal. A party is not obligated to use all the time allotted, and the board may terminate the argument when in its judgment further argument is unnecessary. Respondent appellant is entitled to open and conclude the argument. Parties will not be permitted to read at length from briefs or records. The full membership of the board may in its discretion advise the parties of points upon which it desires to hear argument. Members of the full membership of the board participating in the appeal hearing may ask questions of either party related to issues identified in the appeal. Board members who participated in the board hearing panel shall recuse themselves from participation in the appeal hearing of this matter. Man, ready. The record reflect that the appellant is represented by Mike Hurst,
That's correct.
Deanne Salzman for the state.
That's correct.
Mr. Hurst, would you be utilizing the full 20 minutes?
And Mr. Attorney General, I didn't get your name.
Edward Wiggins, I'm sorry.
Very nice to meet you. Yes, I would like 15 minutes for opening arguments and 5 minutes for rebuttal. And Ms. Wiggins, before my time begins, if I may, I just wanted to compliment your staff here at the Board of Nursing. They've been incredibly helpful. Despite the contention we have between us on this case, Ms. Saltzman and her staff have been incredibly helpful with our client with regard to other issues on this license. So I just want to compliment your staff and tell them what a good job they're doing.
Well, thank you very much. We appreciate that. They do a great job.
And Mr. Hurst, if you want to notice at any time when the 15 is coming up.
Yeah, if you would jump up and down about 2 minutes to go, that'd be helpful.
How about this?
Yeah, that's 2 minutes is perfect. That's even better. Thank you, Mr. Shaw.
Looking forward.
And I'm going to try to keep up with it is here as well. So. Ladies and gentlemen, my name is Mike Hurst. I represent the appellant in this matter, Alicia Puckett Moore. And really this case boils down to 3 things on appeal. Okay. mistake involving the changing of a home address, the misapplication, we believe, of facts to the law. And then finally, as you see in our appellate brief, mercy. We're just asking mercy from this board. Ms. Moore has been a nurse for over 20 years, receiving her license back in 2002. And ladies and gentlemen, for purposes of my argument, I'm going to try to stick to the facts as they were before the hearing board. Ms. Saltzman has pointed out correctly that before you is what was before the hearing board. And I promise Ms. Saltzman is going to correct me if I get outside of that. So 2002 is when Ms. Moore got her license. In January of 2016, you'll see from the agent's report or the written statement to the agent, January of 2016, Ms. Moore stopped practicing as a nurse. She was not practicing at the beginning of 2016. And then just a few months later, in March 2016, was the incident. It was the impetus of why we are all here today. Unfortunately, Ms. Moore was addicted to drugs and alcohol in 2016. In March of 2016, in a drug-induced psychosis, her neighbor called for emergency help. And when the emergency help showed up, Ms. Moore, not an excuse, but not knowing what she was doing under that drug-induced psychosis, bit an EMT on the forearm. Because of that, she immediately went into in-house rehab for 90 days, 30 at Region 8, 60 at Harbor House. And when she came out of that, one of the first things she did, before she was still even practicing as a nurse again, one of the first things she did, she came to this board and self-disclosed. She did what we want all those who have nursing license to do. Come and tell the board what happened. Now, agents came, she gave them a written statement, telling them everything that I just mentioned. When agents came, she signed written authorization saying, go get all of my private confidential information that I have. And shortly after disclosing to the board, she was indicted in Rankin County for simple assault. That's all before the hearing panel. It's all in the record. What's also in the record, though, was after the indictment, the district attorney entered into a pretrial diversion program for Ms. Moore. And if you look in your records in that pretrial diversion program, the district attorney, among other things, found three things. One, the offender poses no threat to the community. No threat. Number two, the defendant is unlikely to be involved in criminal activity in the future. And number three, the offender has no significant history of delinquency or criminal conduct. Now, fast forward over the next few years, again, agents didn't tell her that she had to stop practicing because there was no restriction on her license. Agents didn't tell her she had to go into the drug monitoring program. So for the next number of years, she continued to renew her license with this board on three occasions, 2016, 2018, 2020. And she practiced for the next 6 years without incident. Now, at the end of those number of years, she moved, like a lot of us do. I hate moving. I don't want to ever move again, but she moved. And like a lot of us, especially those with professional license like lawyers, she forgot to update her address. Still had the same phone number with the board, still had the same email. She was actually notified of email to renew her license, and she did. But she failed. She made a mistake to correct her address. In May of 2022, the board issued a complaint against her. And the complaint says, and I quote, that respondent violated Mississippi Code annotated section 73-15-29-1K. Remember that, 1K. And that respondent engages in conduct likely to deceive, defraud, or harm the public. Engages in conduct likely to. The complaint charge mirrored the statute, okay? So in the bottom of the complaint is the factual basis of the complaint. And the factual basis states, while in a drug-induced psychosis, respondent admitted biting an EMT that was responding to a call at respondent's home on or about March 4th, 2016, 6 years later. In the Circuit Court of Rankin County, respondent was indicted for the offense of simple assault on or about September 15th, 2016. In the statement written to the board, dated August 19th, 2016, respondent self-reported being in treatment for drug and alcohol addiction. Specifically, respondent completed 90 days of inpatient rehab, 30 days in Region 8 in Hazelhurst, Mississippi, and 60 days at Harbor House in Jackson, Mississippi. Now, the board sent her this complaint and it got returned because she didn't change her address. The board did what the board was supposed to do. It put it in the paper, which is valid notice. And we're not contesting there was any problem with that notice. So when the hearing came along on October of 2022, she didn't show up. She didn't show up. She didn't know. It was her fault. She didn't change her address, but she didn't know and she didn't show up. And so at that hearing, Ms. Saltzman called Investigator Floyd to testify. And when asked what Ms. Moore had been charged with, Agent Floyd said, and I quote, responded engaged in conduct, likely to, but engaged in conduct. And look, I know we're going back to high school English, and I apologize. I know the board hates lawyers. I'm sure every board I go in front of hates lawyers, but the words matter in our law. And at that hearing, Ms. Saltzman asked Agent Floyd Wiley, was the allegation against Ms. Puckett today that she engaged in conduct that was likely to cause harm to the public and that she bit the arm of an EMT that was responding to help during a drug-induced state? And he responded, yes. Ladies and gentlemen, and I'll get into this a little later, but there were no facts presented that day that proved there was any current or even any recent behavior of Ms. Moore engaging in conduct. There was no facts or evidence produced that day at that October 2022 hearing that Ms. Moore recently or at the time was likely to cause harm to the public. The board issued its final order in November of 2022. And again, because Ms. Moore did not update her address, she didn't get the final order. It was only after she was trying to renew her license again that she realized on the system online that her license had been revoked, and she filed an appeal shortly thereafter. Those are the facts. Those are the facts. Now, ladies and gentlemen, Ms. Saltzman laid this out well in her brief, but to overturn a hearing panel decision, to overturn an administrative decision, it's got to be either arbitrary and capricious without substantial evidence to support the decision, outside of any statutory authority the board has, or violating constitutional rights. And I have to tell you, when we're dealing with licenses and things of quasi-penal punishment nature, and Ms. Saltzman recited this as well, it has to be clear and convincing evidence, not suspicion, not probable cause, clear and convincing evidence. So the first thing I would tell you is, again, going back to grade school, in section 73-15-29, the legislature has put forth 14 different things that this board can use to revoke someone's license, okay? So 9 of those actions are past tense. Past tense. Has committed fraud or deceit, has been convicted of a felony, has negligently or willfully acted, has had a license or privilege suspended. 9 of those things are past tense, things that have happened. It is not 29-1K, which Ms. Moore is charged with. 29-1K states, engages in conduct likely to deceive, defraud, or harm the public. So let's talk about first engages in conduct. The United States Supreme Court says that in interpreting statutes, we have to look at the plain language of the statute. As much as maybe some of us have negative thoughts of the legislature, but We as a society have to assume the legislature knows what it's doing when it passes our laws. It knows how to use past tense words and it knows how to use present tense words. The Supreme Court has stated the same thing. The difference between past tense words in statute and present tense words in statute. And I cited some US Supreme Court cases in our brief. But what I will tell you is cases like this where a license is at stake, the revocation of a nursing license has to be strictly construed against the government that's trying to revoke it, which means the government has the burden of proof here. So there's a case that I cite and Ms. Saltzman talks about in her brief, Mississippi State Board of Nursing versus Wilson, 1993 Mississippi Supreme Court case. In that case, this board revoked an individual's license, alleging, among other things, that he was addicted to drugs. Now, the problem with that is, and the Supreme Court overturned that board decision of revoking that license, was that that individual had been clean of drugs for over a year, just 1 year. And in that case, the Mississippi Supreme Court stated, with regard to section 1H, not 1K, but 1H, talking about addiction, the Supreme Court stated any reasonable interpretation of that statute would require some temporal proximity. That's just fancy legalese, lawyer words, for it's got to be close in time. Temporal proximity of active addiction to a disciplinary action. Okay? So is addicted. Jump down HIJK. And what we have before this board is engages in conduct likely to. Now, Ms. Saltzman makes a good point in her brief. She says the Mississippi Supreme Court also considered that in the Wilson case. The problem is the defendant in that case, Mr. Wilson, did not raise a temporal proximity argument with regard to 1K, with regard to engages in. Engages in that case was about a bad check. And there's nothing in that case about how close in time that check was or anything. So I think we have to look at, again, the words that are presented to us by the statute. Now, let me jump to the second argument in the statute. Engages in is the first one. The second argument is likely to cause harm to the public. Again, the word likely is defined by the dictionary as having a high probability of occurring. Very probable, in all probability, probably. There was no evidence at the hearing panel that Ms. Moore was a high probability of causing harm to the public. In fact, just the opposite was produced to the hearing panel when the district attorney's pretrial diversion document stated that she was posed no threat to the community, unlikely to be involved in further criminal activity, and no significant history of delinquency or criminal activity.
1 minute.
And finally, let me just state, that's the misapplication of law. Engages in, likely to. Finally, mercy. Ladies and gentlemen, Ms. Saltzman is a bureaucrat. I used to be a bureaucrat. We do our jobs to the letter of the law. The reason you're put on this board is because our elected officials put you there. They put you there to show mercy, to show grace, to show compassion. Let's be honest, if Ms. Moore would have changed her address, if she would have showed up here, I don't think she would have been revoked her license. Right now, you guys know this better than I do because you do this for a living. Right now, we are in the worst nursing shortage in our nation's history. Hospitals reported over 3,000 vacant RN positions and 200 to 450,000 nurses vacancies are expected by 2025. This woman has done honorable since self-disclosing and practicing over the last 6 years.
It's 15. You want to take up some of the?
I'll take 2 more minutes. She's trying to support her family. She's trying to support her kids. I know none of that was before you. But I'm asking, I'm begging for you to do the right thing here. Show compassion, show mercy to a mistake that she fully admits she made in not changing her address. And give this woman a second chance by overturning the hearing panel's revocation of her license. Thank you.
You got 420.
Thank you.
Are you using all your 20 at this time?
Hopefully not.
Thank you, Your Honor. First, I'd like to start with the motion to strike any new evidence that was presented on appeal. Mr. Hurst touched on this briefly. It's very clear pursuant to 73-15-31-9, as well as 30 Mississippi Administrative Code Part 2825, Rule 110 B2, that appeals before the full membership of the board shall be limited to the record of the hearing before the board panel. The full membership of the board shall not retry the appeal case. Arguments shall be directed solely to issues from the record of the transcript that results in the appeal decision and shall not include new evidence, testimony, or witnesses. And I think Mr. Hurst would probably agree based on his statements previously that that is in fact the case. So I would ask for a continuing objection to anything that is discussed that is new evidence that wasn't in front of the board panel today. And a record of the transcript from the board panel is contained in Exhibit A of Applebee's brief for reference.
Mr. Hurst?
Ms. Saltzman would, and I forgot to do this, I apologize, but I noticed in,
Stuck this for mine. Getting sorry.
yeah, just pause it real quick. I noticed in the record on appeal, there was no copy, and I may have missed it. There was no copy of the complaint. Is that, you recall a copy of the complaint in the record on appeal?
Yes.
And I was-
Probably just looked at it. Yes, it's in B5.
B5, great, thank
It's
you,
right behind the notice of hearing.
thank you so much. Yes, I do. I apologize.
Did you ever retort to her continuing objection, Ms. Hurst?
Ms. Wiggins, I tried to stay true to the record. I don't disagree with her statutory finding, no, but I tried to stay true to the record on appeal below, and I think I did that. I may have veered off a little bit in my compassion argument, but I think I did that in my factual recitation, so.
Well, for the record, Ms. Saltzman's motion is granted. You may continue.
Thank you.
As was touched on briefly, again by Mr. Hurst, and I'm not going to recite the facts. They're correct. In May of 2022, the board attempted to serve a complaint via certified mail, the statutory requirement on Ms. Alicia Puckett Moore's address that was with the board at the time. As each of you know, it is the duty of the licensee to update their information within 30 days. That's also an administrative rule. And she failed to do that, and she admits it. So we didn't have the correct address on file. There was no way to serve her via certified mail, so it came back. So then we published. We moved that hearing from, I believe it was scheduled in June, to October. She was published. It ran 3 consecutive weeks, again, per statute. He doesn't contest due process here. She was provided notice and opportunity to be heard. She didn't show up. I don't think that's an issue, but those are indeed the facts. In the absence of her being present, board counsel presented testimony that she was not present, that we had not heard anything from her, requesting the matter be continued or excused, produced evidence that we had tried to obtain service via certified mail and also via publication. And then we also introduced exhibits into evidence, and that's what you've heard Mr. Hurst primarily recite from. So today, on an appeal to the full board, the full board's consideration on appeal is limited to determination of whether the board panel's decision was, number 1, supported by substantial evidence, was number 2, arbitrary or capricious, was number 3, beyond the power of the agency to make, which here he doesn't contest, 73-15-29D you have the power to revoke a license. That's not in dispute. And lastly, that some statutory or constitutional right of the appellate was violated. Again, I don't believe that's the issue today. I believe the issue, if I read the brief correctly, is substantial evidence. So these factors are extremely important, and there is a rebuttable presumption in favor of the agency's decision, and the burden of proof is on the appellant to show that one of these four factors has a problem. So on to substantial evidence. Counsel at the hearing, if you would go to Appley's brief, Exhibit A, you will see the documents and exhibits that were entered into evidence. This isn't a big file. It doesn't have to be. Clear and convincing can come from just a few documents and a little bit of testimony. The board panel did not have the opportunity to hear anything from Mrs. Moore because she wasn't here. She didn't show at the hearing. She did not offer anything to refute it because she wasn't present. You will see the complaint that was filed. You will see the publications. You will see that board counsel even provided the board with a copy of her admission. The EMT when in a drug-induced psychosis. You will see board counsel gave copies of her completion of treatment. You'll see that board counsel gave a copy of the pretrial intervention program that she had the benefit of participating in, as well as the dismissal that showed that she completed it in 2018. There was nothing hidden from the board panel. The board panel considered all of these exhibits when they went into executive session, and they came out and they announced a decision to revoke. Again, something they statutorily have a right to do. The question here today is whether or not substantial evidence exists to show that the board panel had clear and convincing evidence of the charged offense. We've gotten into some semantics about engages and engaged, and I'll try to address that in just a second. But I do find it to be important to note that a full picture was given. The board panel just was out the benefit of Mrs. Moore. And I don't think I can emphasize that enough. She wasn't here. I read several cases in preparing for today's hearing. All of the board of nursing cases I found, much like the Wilson case that Mr. Hurst quoted, Mr. Wilson appeared. He gave testimony. He told the board what was going on in his life. He offered mitigation. All of those things are set forth in the Wilson case. The board panel didn't have that here. All the board panel had was what you see in Exhibit A. That's it. Still can be clear and convincing. She admits to the conduct that she was charged with. So humor me for a second. When we're not yet debating engages, engaged, and that kind of thing. She admits to the conduct and she's not at the underlying hearing. I could find no case, none, that had that factual scenario that had been appealed up. Now, we've had a lot of discussion about Wilson, and just to be completely clear, in Wilson, well, in the present case, Ms. Moore was charged with, let me read it straight from the statute, 73-15-21-1, upon proof that such person engages in conduct likely to deceive, defraud, or harm the public. That's section K. The Wilson court took up and Mr. Wilson was charged in that case with 3 different violations of the Nurse Practice Act. He was charged with H, violation of J, and violation of K. This, I thought it was temporal until I heard him say temporal, but that sounded more important. Temporal proximity, that is what the Wilson case turns on. The Wilson case turns on the language that says such person is addicted to or dependent on alcohol or other habit-forming drugs, or is a habitual user of narcotics, barbiturates, amphetamines, hallucinogens, or other drugs having similar effect, or has misappropriated any medication. The Wilson court went on to say that they found the other 2, including K, which is the subject here of today's discussion, engages in conduct likely to deceive, defraud, or harm the public. They found, and I'll read from the Wilson case, We hold the board's finding that Wilson's conduct fell within the purview of section 7315-29-1J and 7315-29-1K was supported by clear and convincing evidence and substantial credible evidence respectively. Again, I cannot emphasize enough, Mr. Wilson showed up at that hearing. And I understand why the mistake is made here. I understand that she wasn't here because she says she didn't know. But I can't overemphasize that it's the burden. It's the rule, the administrative rule is that the nurse, the licensee has to update their address with the board. This board, you're here to protect the public. You're charged with protecting the public. It's your job to protect the public. Over and over, I can't say that enough. The safety, welfare, and the public, that is your role as the Board of Nursing in Mississippi. It is. That can't be forgotten. That is what your role is. And when you have a hearing and you do your best, your legal staff does their best to contact and try to follow the statutory guidelines for service of process, to locate the individual, as we're instructed to do again by the legislature. And we're unable to do that, and we proceed. That's what happened here. We did what we were instructed to do by the legislature too. Is the result harsh? I don't know, maybe, probably. I'll admit that. However, it doesn't negate that there is still substantial evidence in that file to support the decision. This board panel can revoke. They can, they did in this case. They have the statutory authority to. Notice was done pursuant to statutory authority. The only question here is whether there was substantial evidence. And, you know, I didn't address this in my brief, but even if you look at the PMP, which is B9 of the exhibits that were introduced into evidence that day, and look specifically at the time frame that the complaint was filed, around May of 2022. There could be a completely valid reason for those 5 hydrocodone and oxycodone prescriptions. There could be. She wasn't here to tell us what those were.
Your Honor, I'm going to object to this. This is outside the scope of the appeal and it's outside the scope of the appellee's brief as well.
Well, she was charged with engages in conduct likely to deceive, defraud, or harm the public. In that, she bid an EMT while she was in a drug-induced psychosis. Again, I'm not saying there's not a valid reason for having pain medication. But what I am saying is that PMP that was run prior to the hearing in October showed that in that time frame, this occurred. But more importantly, if you look at the ID number, it shows a different address for Ms. Moore, an address we don't have. Not the first address, not the address we currently have, a different address. Does that happen? Sure. But that was all in front of that board panel. We can't forget that that board panel had all of this evidence. Because you look at it and find it to be just a few pages doesn't mean that it's not powerful.
Your response to his objection?
To his objection about the PMP, that was my response. Thought it was excellent. Well done.
Mr. Wiggins, I would just say nothing about B9. It wasn't the record. Nothing about B9 was discussed at the underlying hearing panel. Nothing was discussed in the appellant or the appellee's briefs before this board. It's in the record. Sure, we can look at anything in the record. But now to make an argument that we're caught off guard by, we've never heard from before. The hearing panel never heard this argument. They had the document, but they never heard this argument. I think is prejudicial to our client.
I'm going to disagree with that only just because I was limited to 10 pages.
We both were.
He went over.
Yeah.
My font may be smaller. However, it's in there. It's an exhibit. It is part of the record that was in front of the board panel, and they're nurses. They read PMPs every day. They know how to read it a lot better than I do. So
Me too.
that's my response
I'll
to that.
sustain Mr. Hurst's objection. Are we?
I stopped. She's
Okay.
here at 11 minutes.
Wow, it seems like a lot longer than that. All right, so I don't have to solve it now, maybe. But I do want to go back to the Wilson case for a second and let's argue some verb tense and semantics. That was the bulk of the brief here. The Wilson court found that there was clear and convincing evidence to prove 73, 15, 29, 1K, same thing that we have here. Now, they did require the temporal proximity requirement for H. They did, because it says is addicted to or dependent upon. And they said, okay, it's been several years. And there was testimony to that in the record. We, again, didn't have the benefit of that. This is like a series of choices. One bad choice leads to another bad choice that leads to another bad choice that leads to the end result. Is it unfortunate? Yes, it is. It is unfortunate. But these are our rules. I'm not saying that this is the case in Ms. Moore's case. I don't know. But what I am saying is with a board that's charged to protect the public, when they're not able to locate a licensee, and again, this was in the, I believe Mr. Hurst's brief, he said it had been 2 years. That wasn't in front of the board panel either, but if we accept that as true, and you can object if you need to, but if we accept that as true, she's MIA from the purview of this board for 2 years. So, again, the decision here wasn't arbitrary. It wasn't capricious. Arbitrary is done in a whimsical matter without any thought. Capricious is very similar. The board hearing panel had all of the evidence that the Board of Nursing had. For reasons unknown to us at that time, she didn't show. Hindsight's always a lot better. We didn't have it here. We just didn't have hindsight. We didn't know that the reason we couldn't locate her was because she had not changed an address. I still don't know that to be the case. I assume she's telling the truth, but I don't know that. She was gone. We couldn't find her. We couldn't get her. We did what we were statutorily required to do. The evidence that was in front of the board panel clearly supports this decision. And again, every case against the Board of Nursing that's been appealed up, they were there. They appeared at their hearing. They gave testimony. They mitigated. They argued. I know we're talking about mercy. And I understand exactly what Mr. Hurst is arguing today. I hate it. I'm not gonna lie, I hate it. I don't think it's great. But I do think there was clear and convincing evidence in front of that board panel, and I think there's substantial evidence today to support that finding. I don't think the decision was arbitrary or capricious. It was not in violation of due process or constitutional rights, and it was well within the statutory authority of the board to do. Thank you.
Thank you, Ms. Sullivan.
You just tell me when, Mr. Shaw, because I know I only got 4 minutes and 20 seconds, so
When you start talking, I'll hit the button.
go. Let me, and I want to thank Ms. Saltzman for her honesty. She said this is harsh. She says, I hate it. I don't think it's great. I think we all agree with that, right? She said she was MIA, couldn't find her, couldn't get her. That's actually not accurate because she renewed her license 3 times in that 6-year period. Nothing hidden from the board panel. If you go back and look at the transcript of the hearing, all the exhibits that Ms. Saltzman recited, B1 through I think 9, they're all in there, including the pretrial diversion program. It was in there, just like B9 was in there. But nothing was brought out at that hearing, in the transcripts, about the district attorney finding that Ms. Moore did not pose a threat to the community, is unlikely to be involved in further criminal activity, and has no significant history of delinquency or criminal activity. Yes, ladies and gentlemen, Your responsibility is to protect the public. Your responsibility, but so is the district attorney's. The district attorney made a finding in 2016, 2018, that this woman sitting behind me did not pose a threat to the public. Now, ask yourselves this. When we are in the worst nursing shortage crisis in this nation's history, does it do or potentially do more harm to the public to take a good nurse out of the rotation, or to allow a good nurse to continue to practice and provide services? I'm going to tell you right now, I hope my family doesn't get sick. And we have one less nurse who can't practice, who's been practicing with authorization from this board for the last 6 years. In Wilson, Ms. Saltzman is correct. Wilson addressed it, not only is addicted, and Mr. Wilson argued that there's a temporal proximity. In that case, the Board of Nursing said, we can reach back 10 years. And the Supreme Court said, that's ridiculous. There has to be temporal proximity with is addicted. The problem with Wilson for board counsel is Mr. Wilson did not argue temporal proximity with regard to engages in. What Mr. Wilson argued with engages in is Wilson contends the board presented no evidence of his fraudulent intent. That's what Wilson talked about with regard to 1K, fraudulent intent. He didn't bring up temporal proximity. And I'm telling you right now, if the appellant doesn't bring it up to the court, it's rare that a court will bring it up themselves. That's not the court's job, it's the appellant's job. And that issue was not before the Mississippi Supreme Court. The United States Supreme Court, the Mississippi Supreme Court has all said we have to take the legislature at its word. And in this case, the legislature says engages in conduct likely to cause harm to the public. There was no evidence in this board panel. And I know it's hard. These are fellow board members. I know you don't want to overturn a board panel. I get it. It's human nature. But ladies and gentlemen, there was no evidence in that hearing panel that this woman engages in conduct likely to harm the public. It's been 6 years since the incident occurred when she was not practicing as a nurse, but yet she felt compelled to get treatment, get better, and self-disclose it to you. And if things like this happen 6 years after the fact, folks aren't going to want to self-disclose to you. Folks are going to feel like they've been penalized after the fact. And again, I know I've got 10 seconds. I would just beg you, please allow this woman to continue to practice and protect the public. Thank you very much.
All right, thank you. Mr. Hurst, you referenced a statement from the district attorney about there not being a threat. Where is that located?
Hold on one second, Mr. Wiggins.
About intervention, if you look at the appellee's brief, exhibit A, and you flip over our intervention portion, which is closer to the end, it's, I think, B7, maybe. Is it B8?
B8. The number of pages behind B8, pretrial intervention agreement.
The first page of it, it's March 596 in the upper right corner.
Does the panel have any questions for Mr. Hurst?
Thank the panel for going to lunch and not coming back hangry. So
Does the panel have any questions for Ms. Saltzman?
I have one. I know we've heard a lot about the time. What did occur that made in 2022 to go ahead and do the charge from something that occurred 6 years ago?
I was not here at the time and I did not sign this complaint. The Attorney General's office signed this complaint. I cannot speak to that. I don't know. In all honesty, I don't know the answer to that.
Are there any further questions from the panel for either Mr. Hurst or Ms. Austin? Right, hearing none. At this time, I'll ask that the board interpose a determination regarding whether executive session is necessary in this matter.
Make a motion, we go into.
Second.
It's been moved and properly seconded. All in favor, please signify by saying aye.
Aye.
Any opposed? Motion carries unanimously. Now entertain a motion for the board panel to exit the deliberation on license number R 866201. Motion to the.
Make a motion, we go into executive session. for
Second.
deliberations.
It's been moved and properly seconded. All in favor, please signify by saying aye.
Aye.
Any opposed? The motion carries unanimously. We will return with a decision in this matter shortly. patience. We are back on the record. Entertain a motion for the panel to return to regular session. Been moved and properly seconded. All in favor, please signify by saying aye. Any opposed? Motion carries unanimously. Board panel is now back in regular session. Following deliberation on license number R 866-201, appellant's motion to appeal the board panel decision. The board panel renders the following. The decision of the board panel is reversed. A copy of this order will be forwarded to the licensee within 30 to 45 days of the close of these proceedings. Are there any questions?
Not from appellate, Mr. Wiggins.
Thank you. Y'all may be dismissed.
Thank you.